Jack Smith thinks he's above the law. I already know that because I was witness to his abuse of authority with me in Judicial Watch. I also saw it, or we see it, in our FOIA case where we're seeking the names of his top people working for him. He doesn't want to disclose that. I mean, he thinks he's like a power unto himself. Well, Trump had another miracle this week. Judge Aileen Cannon in Florida, the federal court judge handling Jack Smith's sham prosecution of Trump based on his alleged unlawful retention of documents from his days as presidency, basically said Jack Smith is an unconstitutional abomination. And she shut down his case completely, threw the whole thing out the window. And of course, the left is furious. The Justice Department, I'm sure, if they haven't already, they're about to appeal it. And the decision is worth looking at because it was a brave decision. Judge Cannon has always been under the attack by the crazed left that wants to jail Trump in retaliation for being Trump and to affect and interfere with the election, because Cannon has held the Justice Department to certain basic legal standards and norms and has treated Trump respectfully. And one of the big issues that I've been raising for years, Judicial Watch has been raising for years, is the legality of the whole special counsel operation. I mean, this tweet I posted back in 2018, and I'm sure I was yelling about it earlier because I remember looking at the special counsel regulations when Mueller was appointed. I'm like, wait, this is not legal. I mean, here's the video from a few years ago.
The U.S. attorney is appointed by the president, confirmed by the Senate before he can take up his job. And if there are prosecutors in the Justice Department who aren't subject to confirmation, they answer to people who are, or answer to people who answer to people who are. So there's this lawful delegation of authority. In this case, that doesn't happen. He is not supervised day to day by the appropriate officials in the Justice Department. Therefore, he doesn't really have the authority under our Constitution to do the work he's supposedly wanting to do, which is to investigate, and let's assuming he's doing the right thing and just trying to do his job. It's not about Mueller at this point. It's about the Office of Special Counsel. And if I were them, I'd go back to square one, however politically uncomfortable it is, to make sure that that office is lawful and lawfully run.
I was right. At least Cannon thinks I was right. I was much younger then. It was frightening. I even sounded younger then. I'm glad they caught up to Judicial Watch. And Judge Cannon's decision was a massive victory for the rule of law. And I want to go over the decision a little bit with you because, the media is going to ignore it. Probably would have gotten more attention, but, you had the RNC convention and then the shooting on top of it. So, for obvious reasons, it got buried a bit. Judicial Watch applauds Judge Cannon's principled decision to end this constitutionally rogue criminal proceeding that has so abused President Trump and the rule of law. I am an eyewitness to these abuses as I was harassed personally by Jack Smith's rogue operation. Remember, I was called in as a witness on these documents issues in retaliation, my view is, and Judicial Watch was subpoenaed as well, our documents, in retaliation for our blowing the whistle on their abuses of Trump, suing for information about their abuses of Trump. The decision is a victory for the U.S. Constitution and accountable government. This case should never have been brought, never have seen the light of day. So many reasons to dismiss this case. And Judicial Watch has long called out the unconstitutional special counsels and their attendant abuses of Trump and other innocent political targets. And so her decision, I encourage you to read her decision. We'll put a link to it below. It's widely available. It's accessible. It's a little bit lengthy. But, you're Judicial Watch followers. You know what to do. You can read it. Going to read a part of it to you, though, because it's important, because it highlights how Trump has been abused by someone who shouldn't have had any, who had literally no legal power to do these prosecutions. And she details on the page in the beginning what the issues are. And the first issue is a challenge to Smith's appointment under the Appointments Clause, which provides the exclusive means for appointing, quote, officers of the United States. The Appointments Clause sets as a default rule that all officers of the United States, whether inferior or principal, must be appointed by the President and confirmed by the Senate. It then goes on to direct that Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments. For purposes of this order, the court accepts that the special counsel accepts the special counsel's contested view that he qualifies as an inferior officer, not a principal one, although the court expresses reservations about the proposition and addresses the arguments below. The motion's second challenge is rooted in the Appropriations Clause, which prohibits any money from being drawn into the Treasury unless such funding has been appropriated by an act of Congress. And she cites the clause, no money shall be drawn from the Treasury, but in consequence of appropriation made by law. Both the appointments and appropriation challenges are framed in the motion, raise the following threshold questions. Is there a statute in the United States Code that authorizes the appointment of Special Counsel Smith to conduct this prosecution? After a careful study of this seminal issue, the answer is no. None of the statutes cited as legal authority for the appointment gives the Attorney General broad inferior officer appointing power or bestows upon him the right to appoint a federal officer with the kind of prosecutorial power wielded by Special Counsel Smith, nor do the Special Counsel's strange statutory arguments, appeals to inconsistent history, or reliance on out-of-circuit authority persuade otherwise. The bottom line is this. The Appointments Clause is a critical constitutional restriction stemming from the separation of powers, and it gives the Congress a considered role in determining the propriety of vesting appointment power for inferior officers. The Special Counsel's position effectively usurps that important legislative authority, transferring it to a head of a department, and in the process threatening the structural liberty inherent in a separation of powers. If the political branches wish to grant Attorney General power to appoint Special Counsel Smith to investigate and prosecute this action with the full powers of a U.S. attorney, there is a valid means by which to do so. He can be appointed and confirmed through the default method prescribed in the Appointments Clause, as Congress has directed for U.S. attorneys throughout American history. Or Congress can authorize his appointment through enactment of positive statutory law consistent with the Appointments Clause. I mean, that's exactly what I said in that video. And of course, I was, that was just Tom Fitton, Judicial Watch President. I'm not a lawyer. I'm just trying to understand and cite my objections as best as I understood it. But this is what Judge Cannon said, that if it's maybe inconvenient, but that convenience is necessary to the protection of the rights of American citizens, because these powers have to be exercised by the proper authorities under the Constitution. Remember, I read the Declaration of Independence to you not too long ago. One of the key complaints in the Declaration of Independence was the appointment of all these officers by the king to play overlord for the colonies. They didn't want that. There had to be lawful appointments. I mean, under their theory of the law, Garland could say, hey, Tom Fitton, come on in. I want you to prosecute someone. And I get the keys to the kingdom. That can't be right. Now, some special counsels have been U.S. attorneys or are U.S. attorneys when they were asked to be special counsels. Just John Durham was a U.S. attorney and serving as a U.S. attorney, so that was a valid appointment. Who's the appointment? Who's the special counsel for Biden now? I think it's Weiss. He was. One more time.
Her or Weiss?
Weiss. Weiss is a U.S. attorney in Maryland, or excuse me, Delaware. So that's a lawful designation. Now, there could be an issue about monies being used for special counsels, but that's kind of more complicated issue. Her wasn't lawful under Cannon's theory, right? Because Her was a former U.S. attorney. He retired at the end of the Trump term, and then he was rehired to be special counsel, so he wasn't a lawful attorney. Special counsel. Mueller wasn't lawful, as I highlighted in my video for you. And now the whole case is thrown out. Later in the brief, or in the opinion, and she cites the Supreme Court here. The Appointments Clause is more than just a matter of etiquette or protocol. It is among the significant structural safeguards of the constitutional scheme. And then she points to a case referring to the Appointments Clause as setting forth well-established constitutional restrictions stemming from the separation of powers. Indeed, it is rooted in the separation of powers fundamental to our system of government and to the limitations built into that structure, all of which aim to prevent one branch from aggrandizing of itself at the expense of another. Again, citing another case, the roots of the separation of powers concept embedded in the Appointments Clause are structural and political. Our separation of powers jurisprudence generally focuses on the danger of one branch's aggrandizing its power at the expense of another branch. The Appointments Clause also preserves the constitutional structural integrity by preventing the diffusion of the appointment power and thus enhancing democratic accountability. It's democracy. Citing the case, saying, explaining that the Appointment Clause protects democratic accountability by, quote, by limiting, quote, the distribution of the appointment power, quote, to ensure that those who wielded it were accountable to political force and the will of the people. What's controversial about any of this, folks? I don't see anything. I think it's a well-reasoned decision. Now, you may recall Justice Thomas had a separate concurrence, I think it was in the immunity case, and he had a concurrence basically giving Judge Cannon the roadmap to throwing out the special counsel. He essentially said all of this in his concurrence. Another reason why I love Justice Thomas, because he was the only one who signed on to that concurrence. He said, this is just garbage, these special counsels. They're constitutional abominations. And then the question is, what's the remedy, right? It's kind of a big issue for courts, to put it mildly. What is the remedy? Do the charges remain and they just have to appoint a U.S. attorney? No. She threw it all out. The appropriate remedy is invalidation of the officer's ultra vires acts. Essentially, an exercise of unlawful powers or powers he didn't have. Since November 2022, special counsel has been exercising, as I said, power he did not lawfully possess. All actions that flowed from his defective appointments, including his seeking of the superseding indictment on which this proceeding currently hinges, were unlawful exercises of executive power. Because special counsel Smith, quote, cannot wield executive power as Article 2 provides, unquote, his, quote, attempts to do so are void and must be unwound. Defendants advanced this very argument. Any actions taken by Smith are ultra vires, and the superseding indictment must be dismissed. And the court sees no alternative to cure the unconstitutional problem. It's done. It's done. The court is convinced, she concludes, the special counsel Smith's prosecution of the action breaches two structural cornerstones of the constitutional scheme. The role of Congress in the appointment of constitutional officers and the role in Congress in authorizing expenditures by law. Now, she did find that he unlawfully took money or benefited from the expenditure of tax money by the millions, countless millions, but she didn't see how that could be undone and didn't really address it in terms of, she said I didn't need to get to figuring out how to undo it. She didn't really think there was anything that could be done about it. But in the end, it was further reason, in the least, to throw out the case in its entirety. And it's not just against Trump. He had two of his colleagues from Mar-a-Lago, two staffers who were targeted and vindictively prosecuted by the Smith regime. The framers gave Congress a pivotal role in the appointment of principal and inferior officers. That role cannot be usurped by the executive branch or diffused elsewhere, whether in this case or in another case, whether in times of heightened national need or not. In the case of inferior officers, that means Congress is empowered to decide if it wishes to vest appointment power in the head of the department, meaning Garland. And indeed, Congress has proven itself quite capable of doing so in many other statutory contexts, but it plainly did not do so here. Despite the special counsel's strange statutory readings, nor does his appeal to inconsistent historical practice supplant the absence of actual or textual authorization for his appointment. The same structural emphases resonate in the context of the Appropriations Clause, which embodies a fundamental separation of powers principle subjugating the executive branch to the legislative power of the purse. In the end, it seems that the executive's growing comfort in appointing regulatory special counsels in the more recent era has followed an ad hoc pattern with little judicial scrutiny. Perhaps this can be traced back to the reliance on stray dictum in Nixon. So there was a famous Nixon case about special counsels, and dictum is kind of language that, I'm not a lawyer, so take this my legal definition for what it's worth. Dictum is language in an opinion that typically is just doesn't go to the heart of the opinion. It's just a language that may or may not be useful in analyzing the opinion. So let me give you an example of dictum. The court finds that Tom Fitton didn't speed and get caught by the red light camera, or the red light camera unlawfully caught Tom Fitton. And then there's like a footnote saying, by the way, we don't like red light cameras. Well, that's kind of dictum, because that's not really here nor there. Now, all the lawyers are going to say that was the worst example in the world, but it was the only one I could come up with on the fly, so there's that. So again, perhaps this can be traced back to reliance on stray dictum in Nixon that perpetuated in subsequent cases. Perhaps it can be justified practically by the urgency of national crises, or perhaps it can be explained by the relative infrequency of these types of investigations by congressional intention, or by the important roles that special counsel-like figures have played in the country's history. Regardless of the explanation, the present motion requires careful analysis of the statutory landscape to ensure compliance with the Constitution, and the court has endeavored to do so with care. The court thus returns to where it started. The Appointments Clause is among the significant structural safeguards of the constitutional scheme. So too is the Appropriations Clause, which carefully separates congressional control of the purse from executive power of the sword. The consequences of relaxing either of those critical provisions are serious, both in this case and beyond. As Justice Frankfurter explained his opinion in Youngstown, a famous case on executive power, the accretion of dangerous power does not come in a day. It does come, however, slowly from the generative force of unchecked disregard of the restrictions that fence in even the most disinterested assertion of authority. So good intentions ain't good enough. Illegitimate unconstitutional practices get their first footing by silent approaches and slight elevations from legal modes of procedure. So this creeping unconstitutional power of creating special counsels, hiring special counsels, has been knocked out by Justice Cannon. And the question is will the upper courts, the 11th Circuit or the Supreme Court, uphold her? Because they're going to appeal it. And what does it do to the case up here? I don't know. It complicates things. I mean, Jack Smith thinks he's above the law. I already know that because I was witness to his abuse of authority with me in Judicial Watch. I also saw it, or we see it, in our FOIA case where we're seeking the names of his top people working for him. He doesn't want to disclose that. I mean, he thinks he's like a power unto himself. Supported fully by Garland, of course. But what a great victory for Trump. What a great victory for the rule of law and the U.S. Constitution. Judge Cannon did the right thing, and she should be commended for standing up for constitutional principles despite vicious, unceasing, personal, ad hominem threats and attacks, not only from the left media and activists, but the Biden Justice Department themselves. They have utter contempt for her because she was holding them accountable in a way that no one up here in D.C. was willing to. So kudos to Justice Cannon. I congratulate President Trump, but the battles won't end. I mean, I was noting that now there's another target for the left. Senator J.D. Vance, President Trump's vice presidential nominee. And I issued this warning to him the other day.
Congratulations to Senator Vance for being picked as Trump's vice presidential running mate. As far as Judicial Watch is concerned, it doesn't look like he has any major ethics issues. But my warning to Senator Vance is be prepared for the left to make up fake allegations against you and try to jail you. The left has thrown out any adherence to the rule of law. So be prepared for the deluge. Good luck and God bless.
Yeah. So he should be prepared. And Trump should be prepared for them to continue to throw out all the stops to keep him from office. And I'm not just talking about campaign. I mean the continued abuse of power to target him. And now Vance is going to be in their sights. I don't know what they're going to come up with. They'll come up with something. Do I know it for a fact? No, but experience tells us something. What tells us experience is a great instructor. And my experience is they're going to go after him. So best of luck to Senator Vance in terms of surviving the maelstrom that's coming. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.